the first to know in Nsem-Pii TV.
In the matter of Justice Gertrude Iraba Sackey Tokono, I say every single day bia asem foforo NAP. Recently, and Chief Justice herself, her ladyship, or presenting a writ seeking for 16 reliefs from the Supreme Court. Now, for those following, almost reliefs are Chief Justice is seeking for, but mainly among them, the removal of certain justices from the investigative committee panel. So, investigative panel also because matter discuss matter with which I petitions in sa matter na investigative committee panel no ekwa so na omon na ye edwumadie no edi ruling by in those particular matters, even though justices betima have a different opinion, but the ruling ba na 32 41 71 62 your fan says Supreme Court and I think it decided. Now if the mobile be judge back atutuna no and Chief Justice atutuna no based on the ruling on such cases ebe here say members on your on those particular cases no or on this particular panel. Now yenya from a very reliable source. One of the strategies Chief Justice or pursue in this case. Na BBA friend your eyewitnesses and in conform be witnesses on metimabua defending a particular case, and I say I advance the argument of a plaintiff and I defendant. Mr. Alfred Etua Yebua, a deputy former Attorney General of the Republic of Ghana, only Godfrey Yebua Dami Ayejuma very closely. Now and then one a strong hint on the strategy of the Chief Justice in pursuing this particular case. And I asem or the asem bisa eto say Chief Justice, say Supreme Court and pene amane ni Justice Pwamang and Justice Asiedu from the 5-member panel President Bahama apa so omunye investigative committee na opeso ofro as witnesses in the particular case. For instance, Mr. Daniel Ofori case no, because no motihobi and witness statements by no motihobi and various lawyers advance your argument. No motihobi and go for presenting evidence. In the same crofona no motihobi na as Chief Justice. Justice Pwamang Tiubi, Justice Adibu Asiedu Tiubi. So a person from as witnesses in this particular case. At the advancing the argument, a better no bit my friend, a certain panel judge, a certain panel justice. So all free behind the bench, no better say as witness, name the lawyers and to no based and advancing the argument. It's the part say court no are orchestrating a certain action, a denying the opportunity, so obey engage witnesses be advancing the case. Court na denying an opportunity so obe engage witnesses ebe advance the case. Into Mr. Alfred Etua was say the rates presented by the Supreme Court judge that is the argument or presenting. Into a very likely say court any argument no more to provide the answers to the fact to say a certain panel judge on the matter intimate sounds so better now witness box man. And we judge no send ma Chief Justice Gertrude Sackey Tokono the opportunity so person free Justice Pwamang and Justice Asiedu so better witness box no none the lawyers and to no based on rulings or the buyer in Mr. Daniel Ofori case obenya that particular opportunity. Yes, I'm right. Yenko the former Attorney General Nsem or the Tudra, the strategy of Chief Justice in pursuing one of Ghana's most historic cases. Also, Kasai, former Attorney General, or the legal representative of Chief Justice. The entire or one point said Chief Justice ebeye ne client, and as a Chief Justice, I won't point so obefa Godfrey Yeboah as the lawyer.
It is for the states.
Thank you very much, Samson. I've actually followed the discussions so far and have a lot of things to unpack. One, is it right or wrong for the former AG to represent the CJ in court? That's the first question. And I answer straight away. There is nothing wrong with the former AG, Godfrey Dame, representing the CJ. Why? Godfrey Dame now is a private legal practitioner. As a private legal practitioner, if you are consulted by a client, you may choose to take the brief or reject the brief. And so if he has chosen to accept this brief and represent the CJ, there's nothing wrong with this representation. Again, it is the right of the CJ, as Samson you said, to pick any lawyer of her choice. The CJ has examined most of the lawyers in this country, and he decided that Godfrey Dame should be the person that she thinks should represent her interests in this particular matter. What's wrong with it? There is this argument that this current suit by the CJ is an attempt to frustrate the hearing. That argument is also flawed. The CJ, as a citizen, has the right under the Constitution to vindicate anything that's bothering her by going to court. And one of such is when she's being removed from office. And I dare say, the CJ reserves the right to challenge every step along the way because it is allowed under our Constitution. And one of such steps is what she has done by commencing this action in the Supreme Court. In the current action at the Supreme Court, she's asking for various reliefs. I'm not going to judgmental because I know where I need to tread. But I'm going to state my own opinion, but I will not judge. If a CJ tells you that two of the panel members, I will say panel because they are part of the committee, who are judges, may have to look at their position relative to being part of that committee once again, I think it's a fair demand. Now, even if you go to the chief's palace and there's a matter before the chief has empaneled some chiefs to sit on your matter, it is within your right to raise an objection as to the inclusion of any of the members of the panel. And so in the CJ, it's now saying that looking at the issues at play, Justice Pwamang sat on some cases, and those cases have formed part of the basis for her removal from office. And for that matter, she's of the opinion that it's because to make a determination that Justice Pwamang is not qualified to sit in the matter. I mean, that one is a fair request. As whether to be done by the Supreme Court, we leave it. The second one also has to do with another case where the CJ sat with other judges, including Justice Pwamang. And that particular case is being used for her removal. The CJ says, wait, if you are going to remove me based on this case, a panel member of this committee sat on that panel. So let me ask this question. Whatever the CJ says that she may want to call Justice Pwamang as her witness related to that allegation in that matter, what happens? She tells you, yes, Justice Pwamang is my witness in that case. And so you look at the optics and look at the real circumstances. The CJ had no option than to go to court.
The question arising from what you just brought up has been that, first of all, who empaneled these judges to sit on the matters that she's complaining about?
The president, on advice of the Council of State.
No, the matters that she's complaining that they sat on that matter involving one of the petitioners or more than one of the petitioners, and therefore they shouldn't sit in judgment of her. Who empaneled?
Oh, all right. She empaneled as the Chief Justice.
Right. When she empaneled them, was it her expectation that what they would do would be personal?
Not personal,
but applying the law, right? But applying the law and doing justice, right?
Exactly.
So why does she have a problem now?
You see, she has a problem per her rates because that decision that they took wasn't her personal decision. It was a decision of the panel. And if you are not going to question her based on that particular decision, it will be fair that all members of that panel may have to stay away from it, from interrogating what she did on that particular matter.
Maybe they being part of the panel rather will benefit you.
That's why I pose the question. So if she decides that Justice Pwamang is my witness, I want to call him as my witness, related to that particular allegation, what happens?
Well, how do you answer to the question that in the Daniel Asiedu matter, for example, she had had the opportunity to deal with the matter previously. And then when it came before her, when she was Chief Justice, she didn't see that, what she's raising now was substantive. And so she went ahead. How about that?
I mean, Samson, we do not know the full facts in that particular matter, but I understand that in one of such cases, she was not even part of the panel because she has sat on that case at the Court of Appeal. And I stand to be corrected. And so in those 4 cases, if you have one judge who sat on them, and there's an allegation against a certain Chief Justice related to those particular cases, wouldn't it be fair that that judge does not form part of the panel that's seeking to interrogate that particular matter? Fairness, as we all know, is something that we must all see that is being done or is being done.
Okay.
And let me move further to address this issue about in-camera hearing. Or on-camera. I mean, that's the problem. Is it in or on?
In or on camera. Is it her right to waive?
Let me address you, Samson. Now, if you take Article 146.8, as you read, a careful reading of it, say, oh, this one is so clear. But we are taught that if you want to know the true interpretation of a clause in the Constitution, you must read the Constitution as a whole. And so if you take Article 19.4, clause 14, it's to the effect that if you are hearing every matter, it should be by public hearing. Unless that commission or that committee comes to effect to say that, no, this matter must be heard in private or in camera. And if you also go further, look at Article 281.
No, the article you just referred, does it not defeat the argument that it should be public? Because this provision says it should not be public.
Yes, I'm building an argument.
Okay.
If you look at Article 19.4, it says it should be in public unless or until the committee or the commission says no, it should be in camera. Article 281 has the same provision. And why are they saying that those two provisions they can be held in camera? On 3 main grounds: that if that body is of opinion that based on public morality, public safety, and public order, they may want to say, let's hear this matter in camera. And so the question that comes out is, what is the spirit or the rationale behind Article 148 and 146.8 of the Constitution? The rationale could be deduced, not from the plain text, but you may have to look at the spirit, having in mind other provisions. And in the other provisions, the catchphrase is public morality, public safety, and public order. And so in interpreting Article 146.8, you will have to look at the situation to see whether indeed, in the circumstance of this case, public morality will be defeated, public safety will be defeated, or public order will be defeated. And we should also not forget that they say all proceedings should be in camera. But the proceedings have already leaked. The proceedings have already leaked before we read the proceedings.
When proceedings get leaked, there are sanctions, right?
Samson, I'm coming there. When proceedings get leaked, we are told in the dairy case that it will not vitiate the proceedings, so-called, when they get leaked. Even the provision that talks about shall, the Supreme Court said no, notwithstanding that one, it will not vitiate the proceedings. And so the taking of the Supreme Court in dairy cases to the fact that the leakage of the proceedings or not is inconsequential. And so the use of the word shall there in the Constitution, to my mind, could be interpreted to mean may. And we should not forget, once again, that the Supreme Court in other cases have interpreted shall to mean may.
Like?
You look at the Article 49 of the Constitution.
No, you said
signing of
in other cases. Correct. Signing of pin sheet.
Yes, right. that's what I'm giving you that one.
Okay.
Article 49, dealing with shall, the presiding officer shall sign, etc., etc. Let's go back to 2013 election petition. What was the holding of the Supreme Court? And so you may have shall there, but looking at the purport or the intendment of that provision, is it possible for the Supreme Court to rule otherwise?
You think?
And so this particular
you think the two situations are the same?
Samson, the Supreme Court.
The Supreme Court said the presiding officer is supposed to sign, but his failure, yes, he must sign, but his failure to sign should not be held to invalidate the vote, because the vote was held in the public, it was counted in the public, other parties to the election process also signed. So you cannot punish the voter and all other stakeholders for the sins of the presiding officer. Is that reasonable to you?
Excellent, Samson. So you see here, the Supreme Court decided to look at other circumstances to say, not to stand the shall, it should not affect the outcome.
Correct.
The Supreme Court decided to look at other circumstances, other factors. That is the same way that this case is going to do. We look at the circumstances, the factors. The Supreme Court may, I'm not saying they are going to do that. I'm just expressing an opinion.
So here, what makes the circumstance whatever that should call on the court to deviate from the clear provision? What do you say? That public morality, public safety,
and public order.
How?
Samson. Already, as I said, the petitions are out there.
That is a breach. So that is a breach by who?
If there's any harm, it's been caused.
That's a breach by who?
I cannot point out.
Okay.
It's not leaked. And if the Supreme Court in every case had ruled that such a leakage will vitiate the procedure, it will tell you that the Supreme Court was very mindful of the use of the word shall, just to vitiate everything. But it didn't happen that way. Again, if you look at Article 146.8, I think you ask Amanda a question, whether it creates a right. Article 146.8 creates two sets of things, or more. One is an attempt to limit the right of the person or the subject of the investigation, which may also be looked at vis-a-vis Article 17 of the Constitution dealing with discrimination. Two, the other aspect has to do with the creation of a substantive right for that person to say have the right to in-camera hearing.
Do you think sincerely that 146.8 creates a right?
To me, I see that because it is a right created for the person to say you cannot air this in the public. It is a right.
Really?
It is also a limitation on the right of that person to a public hearing under Article 19.
When the Constitution says that 146, I want to read it again. We have read it once or twice, but I just want to read it again. 1468 says, all proceedings under this article shall be held in camera. Is that a right?
A privilege.
Relative to who? Relative to the subject. So that's why if the current pan decides to say that we are going to hear it in the open, the CJ may say, this is my right. And Article 146.
Relative to the subject, you are writing that into the Constitution. It's not there. All proceedings under this article shall be held in camera.
And if you follow from where you've got into,
yes,
you realize that the target,
yes,
the subject.
There's a comma. Then after that it says a comma, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other person of other aspect of his choice.
So if you look at 146 carefully, it is targeting the subject, the judge.
In my learning, respectfully, in my learning, it is difficult for me to see a right creating provision in Article 8, Article 1468. But once again, we are jumping the gun, are we not? Let's wait for the law lords on the rule side to come out with what will happen.